All right, we are now live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the Massachusetts Appeals Court oral argument for June 9th, 2020. My name is Mary Thomas Sullivan. Today, your panel will consist of me, Justice Amy Blake, and Justice Joseph Didkoff. This is a virtual sitting located in a virtual replica of our courtroom, and it is streaming live. We are displaced from our courthouse named for John Adams, the author of our state constitution, the oldest written constitution in the world, and the blueprint for the United States Constitution and Bill of Rights. John Adams was nothing if not a creative visionary, and we owe a deep debt of gratitude to the clerk of the appeals court, the staff of the clerk's office, the court administrator, our IT staff, and the judges and law clerks whose own creative vision and seamless collaboration made this remote sitting possible. Today, we will proceed just as we would in a regular regular sitting, excuse me. We are hearing 3 cases today, and so we will go through without a break. If you are watching remotely, you can just stay online. The screen will go to black for a short period of time, and then we will resume with the next case. Each side has 15 minutes to argue. There is no rebuttal, and the justices will ask questions. So anything in this proceeding is live and being recorded, and anything said during the proceeding will be heard by all of those who are observing. And with those brief remarks, we will call the first case, which is Lawless versus Estrella, number 19P1278. Counsel, you may proceed.
Thank you, Your Honor. My name is Chip Muller, and I represent Diane Lawless, the appellant. May it please the court. I'd like to point out an error that the Superior Court made in the memorandum and decision, which is in the addendum attached to the my appellate brief. On page 6 of the decision, the Superior Court misquotes a case called Downey versus Chudall when explaining the elements of the way that Ms. Lawless can overcome the conditional privilege. And the judge wrote that Ms. Lawless can show that Ms. Estrella acted with actual malice. And that in and of itself would not be a major concern, except that the judge appears to apply the actual malice standard at the bottom of page 6 and at the top of page 7. She quotes cases like Rotkowitz versus Sandowski, which do not deal with the conditional privilege whatsoever. They're actual malice cases that deal with public figures or public officials. Your Honors, I'm concerned that the judge quoted the wrong law and applied the wrong law and made that error. Similarly, in her section on the conditional privilege, Ms. Estrella, likewise, in her appellee's brief, also discusses actual malice, the actual malice standard, instead of the correct malice in fact standard. The reason why I mention this is that the malice, just to back up, Ms. Lawless does not contest the application of the conditional privilege in this case, but Ms. Lawless does contend that there are ways to overcome the conditional privilege that Ms. Estrella is asserting. And one of the ways this court has recognized that plaintiffs may overcome the conditional privilege is by showing that Ms. Estrella acted with malice in fact or recklessness.
If the email was drafted pursuant to her supervisor's instruction, isn't that the end of the analysis on the conditional privilege?
No, I don't think so, Your Honor. I think that the cases say that the conditional privilege, I think there's no question in my mind that the conditional privilege attaches, and that's by virtue of the fact that Selectman Pacheco requested this letter from Ms. Estrella. However, this court has been clear that there are bounds to what an employee in this situation may say about another employee. One of the ways that Ms. Lawless can overcome the conditional privilege that you mentioned is by showing that Ms. Estrella acted with actual malice or with recklessness. So it is not enough that the letter was requested. Ms. Estrella is still under an obligation to provide useful information to the town within the bounds of the conditional privilege. It is a conditional privilege.
So then that leads me to my next question. I mean, the letter speaks for itself, the tone, the things she said. The end of the day, this is her opinion of your client. Right, wrong, or otherwise, it's her opinion. So how is it actionable?
Well, Your Honor, I'd like to point out that in the appellee's brief, in the section on opinion, Ms. Estrella does not cite to a single case in which the court applies opinion law in the context of a conditional privilege. And this is why I make the point, Your Honor, is that if, you know, the conditional privilege encompasses, I think by its very nature, a person's, it assumes that it is, that an employer, for instance, in this case, is asking for an employee's perspective on another employee. If we were to say, or if this court were to say that by virtue of the fact that Ms. Estrella was asserting her unique opinion about Ms. Lawless, and by virtue of it being her personal opinion about Ms. Lawless, it is a non-actionable opinion. The problem with that is that it would mean that virtually every comment made under the conditional privilege would be non-actionable opinion. And I don't think that that's what the law, the opinion law in this state says, Your Honor. And that's that just because an individual may have a belief about someone or a perspective about someone, if that person's belief or perspective is measurable or testable, then it is actionable. And in this case, Your Honor, Ms. Estrella is not merely giving her opinion about Ms. Lawless, but is also asserting facts about Ms. Lawless. Facts about...
Just to close that loop then, your brother suggests in his brief that most of the statements are true, and you say that that was not raised below. Is that correct?
Yes, Your Honor. It's clear that...
What if some of the statements were true? Taking out the adjectives that she might have used and the descriptive words that she might be upset by, there are things, it appears, that she didn't quite do right. And there were other people that suggested that the environment in the office was not a good one. So if that's true, how does that change your analysis?
Well, first, Your Honor, we do not claim that Ms. Lawless was a perfect employee.
Right. You say that clearly.
Yes, and we do not claim that Ms. Estrella, her statement was completely false. That's not the question. The question was, did it contain actionable falsehoods? So the first thing I'd like to say, Your Honor, is that the fact that other employees somehow corroborate one aspect of what Ms. Estrella offers is irrelevant for a couple reasons. Number one is that it was not raised below, and I can address that more pointedly if you'd like, Your Honor. And number two is that what matters is Ms. Estrella's state of mind in writing this, her intentions and her goals. So the mere fact that two other employees in the office agree that Ms. Lawless was difficult to deal with, that really has nothing to do with the fact that Ms. Estrella said untruthful things about Ms. Lawless. So I think that the court needs to look at everything separately. If we have one, if Ms. Lawless can show that there's one false statement that's actionable, summary judgment should be reversed, and the presence of truth in the email of otherwise, it would have no impact on that reality. As to your question about not being raised below, it is unquestionable, and that's why I filed, Your Honor, most recently a supplemental appendix with the briefing, summary judgment briefing by Ms. Estrella. And what Ms. Estrella did below was make a legal point, not a factual point, a legal point that the gist or the sting, the general gist or the general sting of Ms. Estrella's comments were substantially true. However, Ms. Estrella did not show any lack of dispute of fact that would show that Ms. Estrella's comments were true, and really abandoned, never pursued that angle. So I don't think that, while clearly Ms. Estrella can pursue on a legal basis, some legal theory that the gist or the sting of Ms. Estrella's comments were true in her view, I don't think that Ms. Estrella, I think that the court must assume that all the assertions that Ms. Estrella made in her email are false for purposes of this motion.
Why do we have to assume that? Don't you have to show she doesn't have a basis for the things she says to defeat the conditional privilege?
I have to show, Your Honor, I believe, that she did not have a basis she did not have a basis, or she did not believe that she had a basis. I guess what I'm saying is a more specific point, Your Honor, that there's no defense here that Ms. Estrella can raise that somehow what she said was true, which is a defense to defamation. But I agree with Your Honor that I certainly need to show that, or at least one alternative that I have is to show that Ms. Estrella did not believe some of the things that she said.
Don't you have to demonstrate, though, that she acted out of malice?
Well, Your Honor, that is not the only method. I think that is one method that I can approach this with, and I think that I have shown, Your Honor, and the other alternative is generally recklessness, Your Honor.
Right.
And recklessness, the courts have made clear, does not require ill will or an intentional motive if there is a reckless disregard for the truth. Circumstantial evidence, this case can be proven by circumstantial evidence. Certainly Ms. Estrella and the typical person, the courts recognize that the typical person would not be so unwise as to broadcast their the lack of basis for what they have to say. And so, Your Honor, what I'd urge Your Honors to do is to look at the lack of Ms. Estrella's statement to other people, such as Mr. Brown, her first supervisor, Mr. Healy, her second supervisor, and even Allie Goltz, the administrative assistant in the town hall, referred to as the hub of the wheel of the town hall. Ms.
Counsel, the difficulty I see with your position is that you're saying that because she didn't, in your words, defame her earlier without invitation, then her words are defamatory once requested in the context of an investigation. And that
No,
would
Your Honor,
place
I don't.
Your average employee at terrible risk.
Respectfully, Your Honor, I don't believe that that's what I'm saying. What I'm saying, Your Honor, is that if Ms. Estrella really believed that Ms. Lawless were dangerous enough to bring a gun to work and shoot, she would have notified someone earlier, and certainly that would not be defamatory because presumably she's telling the truth or has a basis to tell someone this, and then it would be acted upon it. But the fact that she did not say that earlier shows that she did not really.
It shows in your view that it's reckless.
It shows
or
that
in
she never
reckless
believed it.
disregard.
Yes, she never believed it, Your Honor.
All right. So
And that
let me ask you a question about what your position would mean generally for workplace investigations. As we know, there are many kinds of investigations that are done, workplace violence, discrimination claims, and the like. And employees do not always speak up before these investigations take place. So if your position is correct, does that mean that any arguably false statement made during a official investigation would open the employee up to a claim of defamation?
I don't think so, Your Honor. I mean, in this case, Ms. Lawless should be able to prove her case with whatever circumstantial evidence is at her disposal. So the fact that Ms. Estrella has a track record of complaints to her supervisors and other people, Ms. Lawless should be able to avail herself of that circumstantial evidence. In the typical workplace, if there is an investigation or someone offers an opinion in the course of an investigation, there would similarly be a track record of interactions between the employee and his or her coworker.
Let's take your classic sexual harassment investigation where somebody comes forward and says, Supervisor X has been groping women and there have been no previous complaints. And the employer goes out and investigates those complaints. And an employee says, I think he may have groped Susie last week. And the supervisor says, I never did that. And Susie says, I don't want to be involved. Does that render the person who relayed that information liable for a claim of defamation?
Well, Your Honor, I don't think so. It's not an analogous situation, Your Honor, because in this case there was over a year worth of track record of interactions between Ms. Estrella and her supervisors. There isn't the same level of maybe fear or shame in making that report in this case, in the instant case, that there might be in the sexual harassment context. So I do think that there are ways that they're distinguishable, Your Honor.
Thank you. And I apologize to my panel members for exceeding my time. Does anybody else have a question though? All right.
Thank you for your time.
Counsel, you can proceed. Wait a minute though, wait for the clock. There we go.
Thank you, Your Honor. In this case, the Superior Court granted summary judgment in Ms. Estrella's favor and decided that this conditional privilege applied, and there had been no abuse or loss of the privilege. And the plaintiff has now conceded that the conditional privilege did apply. So that's really not at issue in the case, whether there was a privilege or not. We're only really looking at whether there was an abuse of the privilege. And when we look at the context in which the statement was made, I think that this is pretty enlightening. The supervisor here, this member of the Board of Selectmen, had asked for employees to be as descriptive as possible. That was Ms. Estrella's testimony. So she put together this multi-page email to the members of the Board of Selectmen, just following her superior's orders here. I wanted to point out a couple.
Fairness, right? She's diagnosing her. I don't think the supervisors asked her for her medical or psychological opinion about Ms. Lawless in the workplace.
That's true, Your Honor. They asked for employees' opinions and what they observed, what their experiences were, and that's what Ms. Estrella offered. And she used some words of caution to say, "I'm not a doctor, I'm not a psychologist, but here's what I observed. Here's what I saw over my 16 months of working with Ms. Lawless." So I think that there's a real caveat there. I know that obviously Ms. Pacheco did not look for a medical diagnosis, and I don't think that's really what Ms. Lawless offered in her statement. It was,
but it certainly sets the tone for the rest of her allegations. This person's crazy. She's going to come in and shoot people up. And oh, by the way, the other things that, as you say, are substantially true.
Yes, Your Honor, and she set the tone of the statement in its very first paragraph to say that the plaintiff had created this abusive, chaotic, hostile work environment. She was belligerent, arrogant, rude, cocky, threatening, and harassing. And then she goes on to describe the reasons in which that was the case. So plaintiff has really parsed out individual elements of this statement, but really when we look at it on the whole, it's the defendant's opinion of her work environment. And then she provided as much detail as she could in accordance with Ms. Pacheco's instructions to do so.
Let me tell you what concerns me. There's one point at which your client writes that Ms. Lawless was speaking ill of the town to bank representatives, vendors, and employees of other towns. And unlike most of the stuff complained here, this is actually something the Board of Selectmen found as one of the grounds for firing Ms. Lawless. And when she was asked about what her basis for that, she mentioned one person, Stacy Long, who was then deposed and said that, she didn't remember anything like that. So could you explain to me why that statement doesn't get to recklessness?
Yes, Your Honor. I think if there is, the cases say if there hasn't been a showing of actual malice, and there hasn't been otherwise a showing of abuse of the privilege, then there can be mistakes, there can be errors in the statement, there can be factual inaccuracies. And I think that might be the case here. We have a brief deposition of Ms. Long, which was taken years after the fact, and her memory may have been different from a subordinate of the plaintiff who worked with her every day. So I think that's the best explanation I can give to the court, is that there might be a factual inaccuracy in the statement, but ultimately it doesn't prove fatal to the privilege. One point that I wanted to make is in response to my brother's first point, was that the Superior Court had made an error in applying the law from the Shoot Hall case. And there may be a misquote from the Shoot Hall opinion, but it really winds up leading to the correct result anyway, because the Superior Court did note that the SJC in the Bratt case has used a recklessness standard, and at least showing of recklessness is required. And the Superior Court went on to find that there had been no showing of any abuse of the privilege. There was no evidence that was put forward that suggests there was an abuse. So whatever mistake there may have been in quoting the Shoot Hall case, it really is a distinction without a difference. It doesn't change the ultimate analysis. The court did include some analysis of actual malice, and actual malice is one of the ways in which this conditional privilege can be lost. So the plaintiff has really not put forward any evidence that would change things from when we had this Superior Court decision. The plaintiff's brief doesn't change the analysis in terms of pointing out additional evidence that would lead to a different conclusion with regard to the existence of malice.
Without going into the details, counsel, is there other litigation pending as a result of this?
Yes, there's another case against the town. As far as the issue of malice is concerned, whether it's actual malice or malice in fact, we don't have any evidence of an ulterior purpose. And plaintiff's argument is essentially that a jury could find, based on some sort of circumstantial evidence. I actually believe that was a statement that my brother made exactly. This is a case that can be proven by circumstantial evidence. I'd suggest to the court that's not the case. We need to have, if there is going to be a showing of malice in fact, then we need to have evidence that an ulterior purpose could be inferred. But where the plaintiff didn't put forth evidence that this court could find that inference, we can't make the inference. We cannot jump to an inference where the evidence doesn't support it in the first place. So it's true that that is one way to defeat a conditional privilege, but applied to the facts of this case, it's not sufficient. Another issue I wanted to raise were some of the other defenses that the court did not address. This court is aware that there was really only one basis for the grant of summary judgment, but the Superior Court didn't address 4 other defenses that were put forward by the defendant. The first one I wanted to address was the plaintiff's status as a public figure. And I bring this to the court's attention because what I think is a particularly important point was something that we raised in a footnote, and perhaps it should have been a little more than a footnote. But the plaintiff's position as the treasurer collector of the town of Freetown was something that she was appointed for, but the town—
What's your closest case, though, just that someone in her position is a public figure?
I think that we can go right to the heart of those public figure cases. In the Stone versus Essex County newspapers case, someone who has substantial responsibility for control of public affairs or has an appearance of such, that's the case here. The plaintiff had control over millions of dollars in debt service and public funds. It was over $14 million, I believe. And we cited to public town reports for that position. So the public, I think that we'd be hard pressed to argue otherwise. The public obviously has an interest in the performance of someone with that responsibility, that level of significant control over the public funds and the town coffers.
Why would this be different if she's a public official? How is the malice requirement for a public official different than the conditional privilege?
A good question, Your Honor. It's a pretty simple, straightforward answer. The burden of proof would be higher for the plaintiff. She would have to establish actual malice by clear and convincing evidence. And in this case, where we are dealing with the scant evidence that the plaintiff has put forth, there is essentially no way, in the defendant's view, that that burden would be met. So, although the town didn't have an election to put Ms. Lawless in this position, she obviously had an apparent importance in the public's mind. So the same discussion with respect to the lack of malice applies, and I think that it is just a much higher burden that the plaintiff can't meet in this case. We had a town of about 9,000 people, and Ms. Lawless was responsible for all those taxpayer funds. I also wanted to address the absolute privilege argument that we made. This was not addressed by the Superior Court's opinion, and I don't really believe it was addressed in the plaintiff's brief either. But one point that I think is particularly salient is when we compare the facts in the Fisher versus Lint case to the facts of the quasi-judicial proceeding here, where this statement was put forward and actually where the statement was obtained, there are some real similarities. We had a 3-member board of selectmen that were impartial fact finders. There were all sorts of other indicia of reliability. The plaintiff was able to test the veracity of the statement if she wanted to. She could have called Ms. Lawless as a witness. She could have cross-examined her, and she didn't. She could have also—
Why is this more judicial than a labor grievance hearing?
Just given the factors that are at play, I believe the defendant's position is that the factors line up squarely with the position that's laid out by the Supreme Judicial Court, or rather, I'm sorry, the Appeals Court in the Fisher versus Lynn case. I think that it might be an apples to oranges comparison, but with a labor relations proceeding, but there are really every other element aside from swearing a witness in under the penalty to testify under the penalties of perjury. Every other element is present. And actually, in one of the footnotes in Fisher versus Lynn, the court noted that witnesses in that quasi-judicial proceeding could have been criminally prosecuted for putting forth false statements in the course of their official duties. And I think that there is an argument to be made that that statute could have applied to the statements that are at issue in this case. We have public employees who are offering statements in the course of their employment with respect to their official duties. So this is just another element that we can consider as some sort of indicia of reliability of the statement. And for that reason, I think that there are real parallels with Fisher versus Lynn. So I know that there wasn't much discussion in the plaintiff's brief, and this wasn't something that was briefed in the district court, but it's worth noting. I think it is a particularly relevant argument, and it merits discussion. The court had previously noted to my brother that the statement as a whole could be potentially considered opinion, and I would agree with that expression. I think that this is a request for a view of work experiences, and Ms. Estrella took it one step further and did her best to provide some support for her opinions. She gave her account of 16 tumultuous months working for the plaintiff, and she did her best to supply all that she could in terms of information to back up that opinion. And for that reason,
if you had been advising her before she sent the email, the things like the gun threat, bipolar disorder, and the like, would those have been in the letter?
I can't say, Your Honor. I do not know. I know that these issues really affected the defendant, so much so that she was willing to put it in writing and provide that information to the Board of Selectmen. And I think it's notable that when the defendant was deposed, she was asked about those issues at length, and she testified that she had a discussion with one of her coworkers, Christina Jusome, about her legitimate fears that the plaintiff would come into the office with a gun. And she testified in some more detail about those issues. She had legitimate fear of that happening. So I can't really say exactly how those experiences affected the defendant, but they obviously did so enough to the point that she thought it warranted putting it in writing. There are several other points in our brief. I recognize I'm running low on time here, but if the court has additional questions on the points that I've raised, I'm happy to address them. Otherwise, I'd refer the court to our papers.
None? Everybody all set? All right. Well, thank you both very much. Well argued.
We are live and recording.
All right. The next case is 19P 1057, Mackey versus Santander Bank, NA, and others. Counsel, as soon as you see the clock appear in the upper left, you can proceed. There you go.
Good morning. May it please the court. I'm Michael Najar on behalf of the appellant, Lisa Mackey. Do you, Justices, would you like a brief recitation of facts, or have you gone through the briefs and have them down pretty well?
You can assume that we are familiar with the facts of the case and your briefing.
Thank you. So the case really is about preserving the integrity of protocols that counterbalance protections when people are allowed to form what are really artificial entities, corporations, realty trusts. People that form those get liability protections. There are others involved that have interests, shareholders, beneficiaries, third parties that are dealing with them that have little or no control a lot of times over what management does. And what we do not allow is for someone to simply use an entity like this and go willy-nilly, alter ego, Superman to Clark Kent, depending on what his or her desires are at any given time. So giving an example, if somebody has real estate and they put it into a realty trust and they're the trustee, and then they smell an IRS audit coming and say, well, I'll put my sister in who's married, has a different last name. They won't spot it so easily, even though the trust terms have a whole schedule of how successor trustees are supposed to be put in.
It's an interesting hypothetical, but let's stick to the facts before us.
Well,
Because the probate court judge has already issued an opinion, which I gather was deemed res judicata as to the husband, that he did not have enough evidence in the probate court matter to find that there was a fraudulent conveyance. So we are looking solely at the trust issues presented in this case involving Santander.
I'm not, thank you, Your Honor. I'm not suggesting it's a hypothetical, but it's just an example of you do that, and then later on, I mean, the probate court also found that in 2011, the mistake as far as Mr. Mackey having resigned as trustee was found when he went to give what were essentially fraudulent mortgages to his parents to dissipate assets, anticipating
But we don't have that case. And
No.
I believe that on both sides, and we'll find out from Attorney Kane, that both of you agree, do you not, that the resignation was effective, and the issue before us is what happened after that.
Thank you. So what the crux of the case comes down to is really pages 8 and 9 of the motion judge's decision, which in the addendum to my primary brief happens to be pages 38 and 39. And it really is that the Superior Court judge determined that there was an essential term missing in the trust that dealt with Mr. Mackey's ability to come back as trustee. What's interesting is at the motion level, no one questioned that he was not authorized to give the mortgage to Santander, that he wasn't authorized to make his sister the trustee, that she was not authorized to reappoint him. And no one really argued any explanation of how Mr. Mackey was able to simply come back as trustee in 2011, 3 years after the line of credit was given to, I keep calling it Santander, it was Sovereign Bank at the time, but it's Santander now. And it was the motion judge who said that there was an essential term missing that she needed to fill in. She said the trust provides explicitly that either Mr. or Mrs. Mackey would serve as trustee as long as one of them was willing, and therefore that she could recognize Mr. Mackey's reappointment. So now Santander argues that if an ambiguity exists, the court strive to discern the settler's intent, then goes on in the next breath to say that the language was explicit and unambiguous, that James shall serve unless unable or unwilling. Well, that's not at all what the terms of the trust says. And the trust terms are in fact unambiguous. And what the Superior Court and Santander have ignored is that James, the trust says, James shall serve until he is unable or unwilling, and then Lisa Mackey shall serve as successor. Very clear line of succession. Anyone else could be appointed only with the signed assent of all beneficiaries.
Or, counsel, do you agree that chapter 203E, section 705 applies, or 704 rather applies in this case?
Well, strictly speaking, the statute was enacted after the events here.
In 2012, but looking at the proceedings before the Superior Court judge, section 66 of the session law provides that the statute is applicable to all trusts and to any court proceeding which occurs after, correct?
I have no doubt. It's very revealing, because what 704 does is it deals with a vacancy in a trusteeship, an appointment of a successor. And if you look at 704A, it says a vacancy occurs if 1, a person so designated rejects a position, or
We
3,
have it.
a trustee resigns. The trustee resigned. If we then look to how 704 fills the vacancy, it does it by Part B, 1, a person designated in the trust as successor, or 2, a person appointed by unanimous agreement of the beneficiaries, or in the final analysis by a court. And if you look at 701,
If I could, counsel,
Sure.
if those are the three options, and I understand that you're arguing that the notion of the judge went down the wrong path on the notion of ambiguity, could not the judge appoint a successor trustee now?
well, what happened in this case was that no one, and by the facts of the case, Lisa Mackey had no idea that her ex-husband had vacated the position. She would have to have been told under 701, she is allowed to be given notice that the trusteeship is available to her. It never occurred. Now, what's interesting, so I guess with your scenario, Justice Sullivan, could the court do it? The court wasn't really asked to do it.
Understood.
Everybody assumed that Santander assumed, Lisa didn't, but Santander simply assumed, well, James Mackey, he's back. He shouldn't have been back. And there's still no real good explanation of how you disregard clear succession terms.
Did you make that argument to the Superior Court judge that those terms could not be disregarded?
Well, I did. I got involved in the case at a reconsideration level. I was not involved up when the initial decision was handed down. And in the motion for reconsideration, I argued there is no really good explanation. You're ignoring the line of succession that's clearly laid out in the trust terms. And if you want to say that the trust terms are ambiguous, the problem is that the trust terms are very much like what the statute adopted in 2012. So we're going to say that, that's somebody can come willy-nilly back in when they feel like it under the trust, under the statute we've been discussing. That's not allowed. And that would mean that anybody that follows that statute thereafter has an ambiguity in their trust.
Here's what I don't understand about this case. Even if you're right, the husband still owes this money that he took to the bank, doesn't he?
Yeah, it's an interest. Yes, Your Honor. By the probate decree, any equity that happens to be in the case was to be split 50-50. Even though the judge determined that half of the line of credit was used to support the family, the other half was used after Mr. Mackey had kind of taken off on his own. But he did say, I don't know what he thought the equity might have been at that point, because he was kind of questioning the validity of the underlying mortgage. But Mr. Mackey would be entitled to 50%. Now, the bank did have Mr. Mackey sign a personal guarantee. So the bank would end up, I presume, attaching anything that were to go to Mr. Mackey, yes.
The probate judge also said that you'll share equally the liabilities on this property. So I don't understand what difference it makes, whether it's through the mortgage or through the husband paying. Either way, your client ends up with the same.
That would presume that it's a liability that Ms. Mackey would be assessed with. And it was, in fact, the probate judge that raised the initial question about this. I don't think this case ever would have got started were it not for comments about that within the probate court.
Well, on page 20 of the probate judge's ruling, it says the parties will immediately sell the marital home and will share equally in all remaining equity or liability from the property. And so what am I missing?
I think what we've got to determine, Your Honor, is this a liability on the property? It's a liability to James Mackey, who gave it an independent and personal guarantee. But if the mortgage is not valid, it's not a liability on the property.
I get it.
Did
Counsel, two foundational questions.
of course.
Who is the settlor of this trust?
Who is the what of the trust, Your Honor?
Settlor.
The settlor was James Mackey.
Where is the evidence of that in the record?
The trust itself, I think, the terms of the
Trust is
trust.
signed.
No, it
And
doesn't
the
say.
property came from the corporation.
Yes, that's right. The property came from his corporation.
So it seems to have been assumed by the parties. And you agree that he was the settlor.
I think I agree that we presume he was the settlor. There was some discussion. I don't know if it's in the record, so I better be very careful here.
Yeah.
I won't say anything. Yeah.
Let's leave it go, because it would seem to me that the intent of the settlor argument might also be illuminated by the documents that would reveal who the settlor was, but we do not have that.
Yeah, that was something I raised in my brief. That there in the reply, I raised it in the primary brief, that when you look at cases that go, what the judge did here is simply looked at the wording of the trust and did not look for affidavits or a trial. I mean, the case law, what little there is, the courts have looked outside the straight terms of the document.
What is your best case for the proposition that the terms are unambiguous?
That they clearly state
No,
if
the best legal case.
primary person resigns, Lisa becomes successor trustee. It's exactly what it says, just the way the statute would have had it say.
What case of the SJC or the appeals court are you relying on for your assertion that that language is unambiguous?
I don't have one.
Okay.
I
And then the final kind of foundational question is that there has been a lot of argument between the parties about how the title search was done. Is there any, and what reasonable reliance may or may not have occurred? Is there any evidence in the record of how a title search was performed in 2008, be it
No.
by hand or electronically?
No, that's the problem with raising that argument at the appellate level, Your Honor.
Well, it doesn't apply to just the Section 34 argument. It applies to the other arguments as well.
Yeah, everybody simply accepted in the court below that there had been a title search, that they missed the resignation and the appointment of Susan Jackson, and that they had missed the resignation of Mr. Mackey initially, so that and everybody said, we know he didn't have the authority to do it. If the Section 34 argument had been raised, I mean, we have no idea to say that Santander relied on anything. We don't know what the abstractor did. And no abstractor would have run this title, plugging in a book and page of a trust, because you have to determine that the land ended up in the trust, and that the trust, before the line of credit was given, that the trust hadn't already encumbered the property. It's only one way to do it. It's to hit the name search. And as soon as you hit the name search, everything comes up, including the resignations. But there really isn't. Again, it's a good point you raise. Had it been raised below, we might have wanted to have experts that do title searches, Dick Howe, the Register of Deeds, and how they were doing, whether they were indexing or marginally referencing. I mean, the thing got indexed, even if not listed as a marginal reference. But nobody was doing marginal references back then. They had already shifted over to computers. My time is up.
Yeah. Your time is up, and thank you very much for your argument.
Thank you all. Thank you.
All right, Attorney Kane, wait for the clock, and then you may begin.
Thank
There
you,
you go.
Your Honor. May it please the court, Matthew Kane on behalf of Santander Bank. Just initially on Justice Sullivan's question about evidence of who the settlor was, I do think at page 49 of the appendix in James Mackey's deposition, there is testimony where he talks about how he consulted with his lawyer and created this trust for the purpose of protecting the asset, which to me indicates that he is the settlor. In any event, that is what the parties assume.
Well, it's on the second page of the undisputed statement of facts, but it was hard to figure out where it came from.
Fair.
The settlor documents are not in the record, right?
Correct, Your Honor.
Okay.
And I guess on that piece, in terms of interpreting what the settlor's intent was, what the Superior Court did was simply rely on the language of the trust itself, which is obviously a primary and the best source for evidencing that intent. And I think that language is pretty explicit at paragraph 9 when it says, for the entire duration of the trust, James Mackey shall serve as trustee so long as he shall be able or willing. And if he's unable or willing, Lisa Mackey shall serve. They get special treatment. And so long as either one of them is able or willing to serve, they shall be the trustee. I think that's pretty unambiguous.
Does that remain unambiguous though, once he resigns and essentially declares himself unwilling?
I think so, because if he shall be, so long as he is able and willing, it's in the infinitive tense. To me, that means he can step in and out as he wishes, provided he's able and willing. And if he becomes unwilling and then later becomes willing again, I think that is sufficient. And that's what the Superior Court found. And so there's sort of two subsidiary questions when you're talking about the trust language. First is the question of whether he can resume. And the second question is the question of how.
So let me see if I get this straight. If he became unable to serve and the wife took over in accordance and accepted the trust, the second he becomes willing or able, he's immediately trustee again and she's dispossessed?
That's less clear, Your Honor. I wouldn't say that that's clear in the trust. But that's not the case we have, obviously, because Mrs. Mackey, Lisa Mackey, never accepted the position, so it was vacant.
Well, she was never told.
She was never told. I agree. And there's ample evidence that Lisa Mackey has a lot of beef with James Mackey as trustee. But that can't be attributed to Santander. Santander was not obligated to tell Lisa Mackey anything. And so
it's true, but doesn't Santander, for better or for worse, ride his coattails in this? I mean, if there's a defect, is it a defect which, again, for better or worse, Santander is stuck with?
I don't think so, because Lisa Mackey's not without a remedy, which is to sue James Mackey for breach of fiduciary duty. And it's not briefed. Well, never mind, I won't go there.
Well, but we've also already had a disposition that the decision in the probate matter is res judicata in this case. So it would appear, and I agree with you that the liabilities are separate, and truthfully, whether or not she has an existing cause of action against Mackey is perhaps something that we don't take into consideration here. We're sitting on a legal issue involving Santander Bank.
And I'll say, yeah, with respect to that res judicata,
title matters.
Correct, Your Honor. And with respect to the res judicata holding, Lisa Mackey chose not to appeal that decision and to try to reopen any possible claim she may have had against James Mackey. And so again, Santander not being a party to the probate case, we have no position on that. But so stepping back, I think there are really two ways you can affirm this. There's the Section 34 argument and the trust language argument. So just finishing with the trust language, I think it's unambiguous that Mr. Mackey can bounce in and out of the trustee position as long as he wants, provided the position remains vacant. To Justice Ditkoff's question, had Lisa Mackey accepted the trusteeship, it would be a different case, but she did not. And the second question is how he's able to resume. And the Superior Court held that his execution of a formal acceptance and recording that was sufficient. And that would be sufficient under the statute. And frankly, the statute requires less. All it requires is that you take some action to exercise control over the trust, which frankly, Mr. Mackey did in 2008 when he executed the mortgage and when he executed the trustee's certificate. I think on those undisputed facts, the Superior Court could have found that that was sufficient at that time for Mr. Mackey to resume the position of trustee. So
what is the intent of the trustee in this? Is it his intent to be able to use this trust as he will for whatever purpose he chooses and to appoint and reappoint himself at will? Is that what we see?
I think what the settlor said his intent was in his deposition was to protect the asset from creditors. And the actions he took really reflect his fear about whether that was going to work out or not. When he appoints his sister, he testifies he does that on the advice of lawyers.
Because he's planning to file for divorce.
I'm not sure that that's what he says. And this was in 2000. He doesn't file for divorce until 12 years later. That's a long plan, if one were to infer that. I don't know the answer to that.
Spend some time in the probate and family court.
Well, one has to wonder why a relatively short period of time after signing these documents, it's only a couple of years, he doesn't follow the terms of them and instead appoints his sister, not his wife, who is the beneficiary. Does that create a fact dispute?
It's an interesting question, but I don't think it's a material dispute, because the question is whether he was permitted to resume the position of trustee. And the Superior Court held, and I agree, that by the plain language of the trust, which says he shall be the trustee for the duration, as long as he's willing and as long as he's able, makes that question irrelevant. We don't dispute, for example, that his resignation was effective when filed in 2000. We also don't dispute that his sister was not a valid trustee. That didn't follow the succession rules in the trust. But we also don't dispute what the trust says, and the trust says he shall be the trustee.
But the trust doesn't say what happens if he steps off, the wife doesn't get appointed. Where is the language that allows him to spring back into that position?
Right, and I turn back to paragraph 9th. And while it doesn't explicitly address that fact pattern, I think it's sufficiently clear, as the Superior Court held, because of that, the tense of the words, that he shall be for the duration so long as able and willing.
And as the bank, what is your responsibility to run this title search 6 ways to Sunday, right?
Well, the facts are that they relied on a vendor, Fiserv, to run the title for them. And the title report is, I believe, is in the record. I don't have the PIN site, but comes back and says that James Mackey is the trustee. And the Superior Court said that wasn't unreasonable. But I don't think that matters either, because what the bank's obligations are curtailed by Section 34. And this is a good opportunity to pivot to this statute. Because what Section 34 says is that if someone takes a mortgage in good faith or an interest in real property from someone who appears to be the trustee in the records of the registry, then it will bind the trust notwithstanding a resignation, unless that resignation is noted in the margin of the trust.
What is the evidence that in 2008, it was possible to notate on the margin of the trust? In other words, depending on the level of computerization of the record in 2008, was it possible to comply with this statute?
I don't know the answer to that, Your Honor, and there is no evidence of that.
Right. And that's a problem on summary judgment, right? Where you carry the burden.
Maybe, but that's only if you assume that the statute being impossible to comply with means, as a matter of law, that it doesn't therefore need to be noted on the margin. You could come out the other way and say, as a matter of law, since the legislative intent was to protect the lender in this case and the people dealing with trustees, that fact of impossibility, the risk is with the grantor, not with the grantee.
There's also some provisions in Chapter 203E. I can't remember exactly which section. It's towards the very end about third parties, but that's when it gets a little tricky to apply a statute that was written in 2012 to a transaction that occurred in 2008.
Yes, Your Honor.
I just question whether we have the record on which to decide the issue you're presenting.
Well,
I appreciate your legal argument and that you've converted it to a legal argument. But
I guess
that's
on
tricky.
the facts, I'm sorry, Your Honor. On the facts, it's not disputed. And in the reply brief from Ms. Mackey, she essentially concedes, I think it's at page 8, carrying over into page 9, that if you looked up the trust by book and page in 2008, that the resignation would not appear in the references. In fact, nothing would appear in the references. So if you want to look at section 34 and try to future-proof the language, so to speak, and modernize it, then I think the technological analog is that noted in the margin can only mean appearing in the reference when you actually look at the document using the computer system. That does two things. Reading it that way accomplishes the legislative intent to protect the grantees, and it also preserves the distinction between the words noted on the margin on one hand and indexed on the other hand, which are two different words and phrases used by the legislature differently. Noted on the margin, setting aside the plain English meaning of writing it down, it means something that you can discern if you look at the document itself. Whereas indexed refers to the system of reference, meaning the document can be found.
So maybe I misunderstood you. Your brother says that if you run JLJM Realty Trust, it says resignation 12/11/2000.
He's correct. It says that.
Isn't that
in the index
of running the trust and the margin entry, if there can be an equivalent, which I don't know if there can.
So to me, the equivalent is looking at the document itself. And if you pull it up by book and page, there is no dispute that in the references, which are the subsequently recorded documents that refer specifically to the trust, in those references, the resignation does not appear. And I don't dispute that if you search otherwise, if you search by JLJM Realty Trust, then in the long list of documents that appear in the index on the left, the resignation does appear, as well as 15, 16, 17 other documents. But I think if you say that that's sufficient, and that means noted on the margin under section 34, then what does indexed mean? I think that muddies the distinction between those words and phrases the legislature was careful about separating in several statutes, where they say recorded and indexed and noted on the margin.
But isn't this exactly why you need to raise it before the motion, Judge, and in your summary judgment papers? Because we're all talking hypothetically about a number of things that we don't have before us.
I grant that would have been better practice. I was not the lawyer below. And I do think that
no criticism to anyone.
Agreed. And I do think that the records of the registry can be judicially noticed at any time. And we're not talking about a lot of facts here, and we're not talking about disputed facts. I think
we can judicially notice what those records look like in 2020. We cannot judicially notice what those records look like in 2008.
That's an excellent point, to which I would say Lisa Mackey has conceded in her reply brief that in 2008, the resignation does not appear in the reference.
On a very different issue, Mr. Kane, if we were to disagree with you on the estoppel by deed argument, the judge never reached your cross claim about unjust enrichment. You did not appeal from that. Is that correct?
That's correct, Your Honor. I've reached the end of my argument. I've got 30 seconds left for questions, if there are any.
Do you think, well, I mean, let's follow up with that. Do you think we have the power to reinstate that count where it was dismissed only as moot?
Absolutely. If you were to reverse the summary judgment order, then I think you do have the power to reinstate that claim.
Are you seeking to reinstate that claim if we were to disagree with your argument, or have you otherwise resolved it?
No, Your Honor, we would want that claim reinstated.
All right.
Thank you, Your Honor.
Your time has expired. Were there any other questions from the panel? Thank you both very much.
All right, we are live and recording.
Our next and final case is 19P0370, DOE number 523925 versus Sex Offender Registry Board. Counsel, when you see the timer in the upper left-hand corner, you can begin. There you go.
May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Doe. As you know, my client was classified as a level 3 sex offender for acts he committed about 7 years ago. I'm here today requesting that this court either lower my client's classification level or remand the case back to the board for another classification hearing. The hearing examiner committed multiple errors in applying some of the regulatory factors in the decision. The first error—
Can I ask specifically about factor 2?
Yes.
Because the Superior Court judge found that it should not have been given aggravating weight, but then in his decision, he basically says if you look at the whole thing collectively, there's no reason to conclude that the level was determined by incorrectly assigning weight to factor 2. If we were to excise factor 2 from the hearing examiner's final classification report, what would we next do? What are the other problems?
Well, my argument is that, I mean, there's multiple problems, but I didn't argue factor 2 in the decision because I'm sorry, in my brief, because I actually
Right.
filed the brief before case number 96 Mass Appeals Court 738 came out. So I did want to argue that too, that was an error as well. But in addition to erroneously applying high-risk factor 2, which, as you know, he shouldn't have applied it here. And that was the only I think there was 2 high-risk factors he applied. And so that was one of the high-risk factors that the hearing examiner applied. And the hearing examiner should have given it very minimal weight or not applied it at all, because as you see, my client was not discovered or confronted or investigated, or he wasn't convicted of another crime. He was in charge or convicted of another crime. But in addition to that error, I also argue that there wasn't enough reason for the hearing examiner to disregard the expert who testified at the classification hearing that my client posed a low risk to reoffend. As you know, Dr. Bard was the only expert who actually evaluated my client, submitted a report for the hearing, and also testified, at the classification hearing. And he also administered a test called the 99R, static 99R. And what he found was that my client only posed a low risk of reoffending. My client only scored a 2 on that static 99R, meaning that he has a 5 to 6% chance of reoffending in a span of 5 years. Additionally, the expert used other factors to determine that my client only posed a low risk of reoffending, such as there was only 1 index crime, 1 victim, it was an incest crime. My client was involved in programming while he was incarcerated, and now is involved in sex offender treatment and also substance abuse treatment. Also, he's was in a stable home environment where he lived at the rescue mission in Springfield. He worked there, he was involved in programming, and he also lived there. So that's another error that I would assert that the hearing examiner committed.
But in terms of the other factors, right, he had a significant criminal record in New York and Massachusetts. He certainly has a history of noncompliance, whether it be by way of probation violations or driving without a license or registration, suggesting that his ability to comply with the law is questionable at best. And I know you make the argument that they scheduled the hearing shortly after your client was released, so he hasn't had time to prove himself. Yeah. But if we look at his historical ability to conform his behavior to the requirements of the law, it's not great.
Well, again, his sex offense was committed in 2013, so that was 7 years ago. And he's been released for at least several years at this point, and there's no indication that he has violated his probation or that he has, strayed away from in terms of committing other crimes and stuff like that. So yes, he does have a criminal record, and he has had a history of violating his probation. But again, too little time has passed, and he is getting older. He was 37 years old at the time of the classification hearing, and I believe today he is 40 years old. Well, he will be 40 years old soon. So there's those two errors that I indicated, and also there's the error of erroneously giving risk elevating weight to factor 12, which is his behavior while he was incarcerated. The facility that he was at did not submit any reports or any indications there was issues with him while he was incarcerated.
But it's ironic, right, that it's your expert that raised that issue.
Yes.
Better or worse, that's what he said.
Yes.
But I thought that the hearing examiner did not give that significant value because there was nothing other than Dr. Bard's statement about some fights in prison.
Yeah, so the hearing examiner did give that minimal weight, but my argument is that without having specifics regarding when the acts were committed, exactly what happened, the expert did indicate that there was fighting, but exactly what happened, we have no information regarding that. We have no information regarding how many.
But so is he supposed to ignore what your expert said?
I mean, you're right. It's a factor that I did go back and forth in terms of whether or not he even bring it up as an issue, but given the total lack of information from the facility itself, the board had the opportunity to provide that information and failed to do so. And again, the burden, I'm sorry?
And they didn't do that.
And they didn't do that. And as you said, unfortunately, it was via Dr. Bard that information was given to the board and to the hearing examiner, unfortunately. But again, we don't know how serious the events were. We don't know how many times he got into fights. We don't even know if maybe he appealed it and maybe it was not even part of his record anymore. There's just so little that we know about it. So I think that the hearing examiner should have given my client the benefit of the doubt and just not given that risk elevating factor anyway.
I'd like to return to Judge Blake's first question, which is that when you have an error on high risk factor 2, repetitive and compulsive, and the hearing examiner did rely on the regulations, the Superior Court judge did rely on the regulations in making his decision that he would not consider high risk factor 2. How important is that kind of an error? We have a lot of cases that tell us that weight is for the hearing examiner and balancing is for the hearing examiner. And I appreciate your arguments on the other factors, but it's difficult business to say under some of our cases that the expert's opinion should have been adopted.
Mm-hmm.
The distinguishing factor in this case is the error on high risk factor number 2. So if you were to focus your attention on that, how important is it or not that the motion judge said not, given everything else, given his criminal history,
yeah,
etc.
Yeah, no, and I could appreciate where the Superior Court judge was coming from with that, but my argument is that is a high risk factor, and I respectfully disagree in terms of the importance of that factor versus the other factors that were present in this case. Again, that was one of 2 of high risk factors that the hearing examiner applied against my client. And had he not applied that high risk factor, I would assert to you that my client should not have been classified as level 3. Again, he was convicted of 2 counts of indecent assault and battery. The hearing examiner himself found that it was touching. I'm not, obviously what my client did was horrible, but it wasn't the same as penetration. And it was one victim, and it was somebody who he was related to, who he lived with for, I believe, 12 years. So
Well, they weren't related. He wasn't the dad, right?
He wasn't the dad, but under the factors, he would be considered intrafamilial because he had a relationship with the mother and had lived with them for 12 years. So under those circumstances, giving high risk weight, giving aggravating weight to this high risk factor, I think is something that the court should consider. As the Superior Court indicated, it was an error. And additionally, my client received no risk mitigating weight for factor number 32, sex offender treatment. My client did get enrolled in sex offender treatment.
But at the time of the hearing, he had only had one
Yes,
visit. And while
yes,
he was incarcerated, he did anger management and substance abuse.
yes.
Was he offered sex offender treatment and declined it?
I believe it wasn't offered where he was in the House of Correction. I believe they don't offer sex offender
Okay.
treatment there. Yeah. But he did enroll. So he enrolled in June 2017. He was released from incarceration May 2017. And the second day of the hearing took place in August 2017. So really, there's really little time to establish any specific facts regarding how he's doing in treatment. And he does, he has no say in terms of when the hearing takes place. Actually, the first day of the hearing took place while he was still incarcerated, and the second day took place when he was released. So he had no control over when the date of the hearing was going to be given. So I would assert that he does have a lower risk of reoffending, given all the facts involved in this case. Again, it was one index crime against someone he knew. The expert is the only person who evaluated him, and he found that he was a low risk of reoffending. My client was given 3 years probation, which does expire September 2020. He's involved in sex offender treatment, and also he was in a supportive environment at the Mission Rescue in Springfield, where again, he worked, he lived there, he was involved in multiple programs by all accounts.
Can I ask about something that Dr. Bard apparently testified to? It shows up in the examiner's report at footnote 4, which is 119 of the record. Dr. Bard does not consider the petitioner's years of sexually abusing the young prepubescent victim to be evidence of a fixation on children as sexual objects. And obviously, the examiner found otherwise. Doesn't that somewhat undermine his entire testimony, that he didn't think that this young girl, who was 13 at the time of disclosure, but much younger, when she was sexually abused for 5 years or 6 years, was not a sexual fixation on children? I'm struggling with that.
Yeah, I mean, I can't get in his head, so I don't know what he meant by that exactly. But what I assumed he meant was that there was only one victim. So it wasn't like there were multiple victims and they were all, really young. So I think that's where he got the word fixation, that this isn't a person who is fixated on continuously sexually assaulting young girls. That's what I gathered from it. It looks like the hearing examiner may have read it a different way. The expert does indicate in the testimony and also in the report that he does believe my client committed these offenses. And obviously the victim was a young child. But
and to that end, your client still denies that he committed these offenses.
Yes, and what happens a lot of times with sex offender treatment is that in the beginning, clients do deny it because they don't want to admit that they did something so horrific. But then as they're doing the treatment, eventually a lot of them do admit and do take responsibility. And again, my client had just started sex offender treatment, had only been a month.
Counsel, before your time runs out, what's wrong with the examiner's application of factor 2?
So well, first it says that he gave that factor applied aggravating weight to it. There's no indication of exactly how much was it. I agree with the Superior Court judge at this point where there was no indication of how much weight. Was it the minimal weight? Was it increased weight because my client was discovered and then continued? Or was it the highest weight, which is when somebody is convicted of a crime and then continue and then, commit another crime? So there's a question regarding that. And again, it's a high risk factor. So I think it's, if that factor weren't present, I think a really good argument could be made that my client level 3 classification is too high under these circumstances. And lastly, I would argue that this court should remand the case back to the Sex Offender Registry Board, as the hearing examiner failed to make any findings that public safety interest is served by internet dissemination of my client's information. In my opinion, it wouldn't really protect the public from him. As you know, he sexually assaulted a girl who he lived with. He was involved in a long-term relationship with her mother. It was somebody he knew, somebody he lived with. It happened 7 years ago. And as you know, the expert had found that he was a low risk of reoffending. And as it stands, or as it stood during the time of the hearing, he was living a productive and supportive environment. And for these reasons, I request that this court remand the case back to the Sex Offender Registry Board. Thank you.
Thank you.
If no further questions, I'll rest on my brief.
Fine.
Thanks.
We will wait for the clock to be reset, and Attorney Cheney, you can continue when it is. There you go.
Good morning, David Cheney for the board. The factor 2 issue, 23656 didn't say that that it wouldn't be applicable under these circumstances. What it said was, when you have a case like this where there was multiple incidences of sexual misconduct and there was an opportunity between the time of each conduct for the individual to reflect on the wrongfulness of his actions, at that point, it would apply, factor 2 would apply as threshold weight. So factor 2 is applicable in this case, just that threshold weight. And the mistake was that the hearing examiner gave aggravated weight to that, which, as we know now after 23656, only occurs when an individual has been investigated and then, or convicted, and then commits another act of sexual misconduct.
So you agree that saying aggravating weight is an error without someone being caught?
Correct.
What does aggravating weight mean? Does that mean high?
Aggravating weight, I think what the court in 23656 said, basically that the first stage is threshold weight, the second stage where someone's investigated or confronted and does it again, then that's more of a aggravated moderate weight. And then the highest rate would be someone who's been charged with or convicted of a sexual crime and then commits an act of sexual misconduct. I think that's how the court broke it down.
Well,
So
I'm familiar with the case. My question for you is, what does aggravated weight mean in this case? What does that finding mean?
That would be more of a moderate weight under 23656.
No, I'm asking what the hearing examiner meant in this case in terms of how SORB operates. When they say aggravating weight, do they mean medium or high?
I would guess in this case he was saying high.
Okay.
But the question isn't so much really. I mean,
hold on.
You got
so everywhere where he says aggravating weight, we should read that as high aggravating weight.
I would say yes. But what happens here is you have to look at if factor 2 were applied properly as a threshold weight, would the rest of the evidence and would the rest of the factors still validate the level 3 classification? In the board's position, it would. You have an individual who sexually abused a prepubescent child for 4 years, ending in 2013, and since that time spent 2 years between 2013 and the incarceration before his release. 2 years of that was through incarceration. He's just beginning his programs. He has a history of probation violations, and Dr. Bard was clear. His risk will only remain low if he does well in probation, does well in sex offender treatment, and does well in his sobriety, none of a history which this individual has never followed.
Speaking of sobriety, was it error for the examiner to apply high aggravation to factor 9?
No, the individual had a huge history of drugs and alcohol abuse. During the time he was sexually abusing the girl, it was the time that he tried to buy 100 Percocet pills. So obviously he was having trouble with addiction even during that time. So it's not, and again, even Dr. Bard admits that alcohol and substance abuse is a disinhibitor, which is a risk elevating factor. And the fact that this individual is indicating that, the evidence indicates that this individual was dealing with substance abuse issues while he was sexually abusing this child. And again, Dr. Bard says if this individual does go back to using substances, his risk will elevate.
But does it make sense? I can see why it's aggravating, but why does it make sense to have high aggravating when the examiner says that he's encouraged by his actions towards sobriety, and he seems to be sober now. I get aggravating, but the high, I'm not following.
Oh, the high is based on the fact that, again, his history, and you look at the history of substance abuse, the fact that he was obviously involved with substance abuse at the time of the sex offending behavior. Those are high level risk factors because it indicates an individual who, when he is consuming alcohol or substance abuse or is involved with substance abuse at that time, is a higher risk to commit a sex offense. It's more of a
high aggravating on the next factor, number 18, where the person is just, the victim is only 1 year younger than the age at which that applies.
Well, again, he began when the child was considered by the board to be a extra vulnerable child, and that factor there, it's highly aggravating because it's a high aggravating factor. Just its application alone is high aggravating. That one, I don't think you divide up and say because the child was 1 year away from being 8 years old, it's less. I think if there's a reason why 8-year-old is the cutoff. Anything before 8-year-old. That is a high aggravating factor, and I don't think you can get around that. I think going after an extra vulnerable victim, and that would include someone over the age of 60. If the person is 61 or 70, I don't think it, in the regulation, it differentiates for the high aggravation part of that factor, which is that an offender would actually target an extra vulnerable victim. And the reason they target that extra vulnerable victim is because it's harder for that victim to defend themselves, and that's the reason for that aggravating factor.
Do you agree with Ms. Hernandez that sex offender treatment is not available at the House of Correction?
I believe if he was at the, and I'm sorry, I've got so many of these going, but if the Hampton House of Correction does have a sex offender treatment program, it's not the mass treatment center program. It's more of a whole person, but it includes sex offender treatment. And my understanding is he didn't take that program.
What's difficult in this case, though, is that the hearing was scheduled so soon after his release that he really didn't have the ability to show how he was going to do in the community. We only have one sex offender meeting. The drug and alcohol therapist, he really wasn't given the opportunity to show that he could stay clean and sober and benefit from the treatment.
Well, you got to remember that the board's regulations require, and the courts have upheld this, that offenders be classified prior to their release from incarceration or soon as possible afterwards, because it's their current risk. They're not. The law and the regulations and case law stands for this, that the board doesn't have to wait till an offender's out for a year to see how he's going to do before they classify him. It's his current classification status as he's released from incarceration.
So if we would uphold this classification decision, when could he next apply to be reclassified?
It would be 3 years from the final classification decision. So basically, technically September of 2020.
And
I was going to bring that up now because the law has changed. Every 3 years, an individual has the right to not only have a reclassification, the board has the burden by clear and convincing evidence to establish what their at that time, what their risk and danger is. And that's interesting because I'm finding with these appeals, and I've said, I feel like I'm on a treadmill. We finally end it, and 3 months later, I'm back in on a reclassification, and we start the whole process again. So he does have that right, and he can apply in September of 2020 and ask for his reclassification. And that's the interesting thing. When someone's released from incarceration and he has, within 3 years, he's going to have the right to bring it back if he's made those steps and shown that he's done the things he needs to do. But when he's first getting out of prison, it's the board's requirement that they protect the public from someone who at that point is currently a risk and danger. And in this case, again, because there was so little time and this person's past history, it was incumbent that he be classified prior to or close to his release time. and again, I think this goes back to why dissemination is required in this case, is because this is an individual who had been in prison since his sex offenses. In a 4-year period, he spent 2 of those in prison, and then when he was released, he has a history of violations of probation. He has a history of substance abuse. He has a history of not following through. So there's no guarantees when he's released that he's going to cooperate and do well. And Dr. Bard is clear, if he doesn't do well, his risk elevates. Dr. Bard's final analysis was based basically on the belief that this person will do well. But there's no evidence in his history that he does well or would do well. So I think the 3 years.
Why did the board have the D reports from his incarceration?
Why do they, or
why didn't they have them in this case? We only know from Dr. Bard that he had disciplinary issues while incarcerated.
Right. Usually this is why, usually when we get House of Correction records, they really don't send us the disciplinary records. And for whatever reason, the state prison always sends them. The House of Correction sends kind of like a thumbnail of what programs they were involved in, what they've done. They generally don't put a whole lot of information into.
But what prevents SORB from asking for it?
Well, in this case, we could have asked for it, but the reality was, if we didn't ask for it, it only hurts our case. So we didn't have the information that he had disciplinary problems. Dr. Bard basically flagged us to that there were disciplinary problems. And still, the hearing examiner only gave them a weight to that factor.
It also harms our ability to properly adjudicate the case.
Absolutely.
Correct, but again, we can only get the records they give us.
Why can't you ask for more?
I guess we could. I guess we always felt that we were getting what we had. This is the first time I've ever heard where we got records from the House of Correction and someone came in and said there was records we didn't get, or any prison. This is the first time I've ever seen this happen where reports came in and the other party's experts had said, wait a minute, he also had disciplinary problems that we didn't know about.
Seems like something you should follow up on systemically.
Systemically, possibly.
The hearing examiner needs the most information possible. And I continue to struggle with what the difference is between a level 2 and a level 3 classification. The more information the examiner has, that Superior Court judge has, and that we have, the better able we are to rule on these cases.
Well, I understand that. Again, that's a whole different level of the board that I'm just here defending what they give me. I can't
Fair
get
enough.
them. Many times.
Fair enough.
Emotion.
But now you get to say that you were asked this question at oral argument.
Yeah, and I always send that information back up. I think we had one last week where I sent up a memo about it, and what they do with it once it goes up there is sadly out of my hands. I'm kind of low on the totem pole when it comes to these things.
I very much appreciate that you sent a memo about our discussion last week. That's really great to hear.
Yes.
Yeah, well, because it's important that the board, at least the higher levels of the board, know what the courts are talking about and what questions are being asked. And I do forward it up and I do tell them what needs to be done or how to look at it. And again, I don't have control once it goes beyond me, but I do memorialize these things.
Thank you.
And if there's no other questions, I can rest on my brief at this point.
We all set?
I'm all set.
All right. Well, it's a short list today. That concludes our proceedings. Thank you very much to the parties for your arguments. Thank you to our IT staff and the clerks and everybody who made this virtual sitting possible.